So on May 17th, 1954, 70 years ago to the day, the Supreme Court ruled that racial segregation in public schools was unconstitutional. That landmark decision was hard fought and the result of a multi-year campaign to persuade all 9 justices to overturn the pernicious separate but equal doctrine that their predecessors had endorsed in 1896 in Plessy versus Ferguson. Thurgood Marshall, the founder and the first president Director-Counsel of the Legal Defense Fund, was the legal architect behind the strategy in the case, and he recruited some of the nation's top attorneys to join him. I want to name those attorneys today. They are some of the many unsung heroes of our history. They include Robert Carter, Jack Greenberg, the second President Director-Counsel of the Legal Defense Fund, Constance Baker Motley, an LDF lawyer, first black woman to serve on the federal judiciary. Spotswood Robinson, Oliver Hill, Lewis Redding, Charles Scott, John Scott, Harold R. Boulware, James Nabrett, and George E.C. Hayes. So tonight, as we commemorate the case that transformed our nation and marked the beginning of the end of legal apartheid in this country, we must not only recognize its lasting legacy and impact, but we must also wrestle with whether we are living up to its promise. So I'm going to start the conversation. We have assembled a themed panel this evening, so I want you to join me in welcoming them to the stage. I'll start with our moderator, Emmy Award-winning journalist and WUSA 9 anchor, Larry Miller. Our first panelist is my partner in leading the Legal Defense Fund, the inimitable Janai Nelson, President and Director-Counsel. Next, we have Julián Castro, the CEO of the Latino Community Foundation and the former Secretary of the Department of Housing and Urban Development. Next, we have Kimberlé Crenshaw, the co-founder and executive director of the African American Policy Forum. Next, we have Kenji Yoshino, the Chief Justice Earl Warren Professor of Constitutional Law at the New York University School of Law. And we have DeAndre Arnold, who is a current undergraduate student and LDF client in a hair discrimination case in Texas. We will also be joined by Derrick Johnson, the president and CEO of NAACP shortly. So Larry, I'm going to turn it over to you now.
I'm really excited to be here with you today. I think we're looking forward to what will be a thoughtful and comprehensive conversation about what our world looks like now post-Brown and where we still need to go. As we know, the organizations that are represented here today and those that work both directly and indirectly with these respective organizations do incredible work in trying to provide equity for us all. But that work is necessary and it needs to continue. We'll talk about that as we talk with our panelists today. So we will start with our first question, our opening questioning here. As you all know, LDF's theme for the 70th anniversary is We Are All Brown. What does Brown v. Board of Education mean to you personally, and how do you think it has affected the trajectory of your life and career? Who would like to start us off?
So good evening, everyone. It's wonderful to see this full rooftop. And thank you so much to all of our panelists for joining us, and to our Associate Director Counsel, Tona Boyd, for that amazing introduction. I also want to thank our staff. We have a number of staff members here who contributed to this event and who do the work of the Legal Defense Fund every day. So thank you. I salute all of you. And I also want to say happy National Brown versus Board of Education Week Day. okay? Because this is something that I believe should be a holiday in this country. Brown versus Board of Education, as Tona said, is the case that transformed America. It was a pivotal moment in our history. And so when I think about what Brown versus Board of Education means to me, it means that we can use the power of law and the power of people, the clients. If we think about the Brown case, just that one case, remember it was 5 consolidated cases, but even just the Brown case alone out of Topeka, Kansas involved 20 children and 13 parents. Those are the people who powered that decision with many others in various communities across the country. So Brown inspires me to think about the will of individuals and communities to change something as formidable as an entire structure of legal apartheid. And if they can do it, that means that we all somehow have the power to do that as well. And I really got introduced to the Legal Defense Fund through the case of Brown versus Board. We all heard about it in elementary school and, as people, and I had no idea the full story of that decision and all that it transformed. When you hear about it, you think that it means that Black children and white children get to learn together. But as you study that case more, you know that it means something well beyond that, that it is a case about true justice and equity. And it's not just about integration. It's about the allocation of resources. It's about power. It's about access to opportunity. And that is what we want to restore as we think about Brown, not this simplistic version, this reductionist idea of what Brown is. So that's really what the case means to me. And we came up with the concept of We Are All Brown to really call people into owning the decision and owning how much it informs our future and our responsibility to make sure that we carry Brown's promise forward, that we're all the beneficiaries of Brown, and therefore we have a responsibility to steward it. So that's why we said we are all Brown, because all of us have been affected by it, all of us have been improved by Brown. This country has been elevated by Brown, and so we all need to own that responsibility. So that was an effort to call people in to embracing this transformative decision.
Thank you for the invitation to be here. It's a real honor to get to participate tonight. To me, the Brown decision, of course, to all of us, it had a profound impact on our country. To me, it signifies in my own personal life access to opportunity that I'm sure that I otherwise would not have had. I grew up with my twin brother Joaquin on the west side of San Antonio, in the San Antonio Independent School District and the Edgewood Independent School District that were probably between 85 and 90% Mexican American. And it was Brown and decisions before it and after it that laid the foundation for improvement when it came to educational equity for the Black community, but also for Brown communities throughout the United States. And I'm very grateful for the lawyers, for the plaintiffs, for all of those that sacrificed a lot to make Brown happen. And as y'all know better than I do, that it didn't happen overnight. It happened because of a lot of pushing and pushing and pushing and great legal strategy and brilliant folks who were perseverant, wouldn't give up. And I consider myself a direct beneficiary of that, especially as one who went to the public schools of San Antonio.
So Brown for me, so quite literally I wouldn't be sitting here were it not for Brown. And it's not simply because of the way that Brown's wider, broader shadow pressed on other institutions to open their doors to people like me who were underrepresented. But because the very idea of being a lawyer came from Brown versus Board of Education. When I was growing up, a lot of Black families like mine had sort of this pantheon of photos on their wall. It usually included some combination of Jesus, President Kennedy, Martin Luther King, and some of them ended with that. We had all that. We also had a photo of Thurgood Marshall. And we also had a photo of the black representatives in Congress from the Reconstruction era. So I grew up with my family talking about the importance of law as a mechanism, as a tool that we could use in order to better our position. So I used to play at being a lawyer in the neighborhood, like holding little courts and stuff like that, settling little disputes. But it really did come from this recognition that there was this discourse, there was this institution, there was this thing that we could appeal to better our chances in this society. So it was natural that I would eventually go to law school. And it's that kind of aspirational dimension. I mean, the things that you believe when you're a kid stick with you even as you go through life and you realize some of that stuff didn't quite work out in the way you thought, or it was a fantasy, or people are pushing back. But because my first introduction to the idea of race and law was through the image of Thurgood Marshall, that, you know, that hope springs eternal, that we are able to use our skills and use our arguments, and that the institution that is supposedly there to advance this democracy will stand up and do the things that it's supposed to do.
Which I think kind of to sum that up in part is, if I can see it, I can be it, right? Kenji, how about you, sir?
Yeah, thank you so much for having me this evening. When I think about how and I think about two other constitutional rights cases, one is versus Texas in 2003, often known as the Brown v. Board of the LGBTQ plus movement, and the other one is United States versus Korematsu, a 1944 case that approved the internment of the Japanese. So I wrote the International Human Rights Brief in Lawrence versus Texas that Justice Kennedy cited in his majority opinion, and I've been driving the gay rights movement for a long time from my kind of academic perch. But the story I want to tell today actually has to do with the author of Brown v. Board, and that's Chief Justice Earl Warren. So I used to teach at Yale Law School. I occupied a chair there that was named after the judge for whom I had clerked. When I was being recruited by NYU to go to NYU, the very savvy dean said to me, we tried to find a chair of equal sentimental significance, couldn't find one, so we created a new chair, and we're naming it the Earl Warren Professorship of Constitutional Law to honor the work that you do at the intersection of civil rights and constitutional law. And every people-pleasing bone in my body wanted to just accept the chair, which had been offered with all goodwill in the world, but I knew that I could not. So finally I said, I can't take that chair. And he was astonished, and I could tell a little bit annoyed. And he said, why on earth not? We raised $5 million for this. I hope you know how much work has gone into it. And I said, I'm very sensible of that, but as you may know, I'm of Japanese descent. And as you may know, as Attorney General of California, Earl Warren superintended the internment of over 100,000 individuals of Japanese ancestry without any due process or criminal charges. And I cannot be honored with the name of a person who has so dishonored my people. So he said, like a good dean, please don't make any sudden movements. I'll get back to you in 3 days. 3 days later, the phone rings. He says, I have a new chair for you. And I say, great, what is it? And he said, it is the Chief Justice Earl Warren Professorship of Constitutional Law. This time, I'm the one who's a little bit annoyed and completely astonished. And I said, what difference could that possibly make? I just rejected this chair 3 days ago. You've added the word Chief Justice to the front of it and presented it back to me as if it's a completely new chair. And he said, please hear me out. In the intervening days since our last conversation, I've read a biography of Earl Warren. In that biography, he's reported to have said that the thing that he most regretted about his life was the internment of the Japanese. So he said, given that your project, whether you call it civil rights or diversity, equity, inclusion, is a project of taking people from where they are and trying to get them across that arc, right, to thinking about how many different valid ways there are to be a human being, what better title could you have than the name of an individual who was able to travel so far over the course of a single lifetime, but at the point where he was completing rather than beginning that journey. So I said, that chair I can take. So I sit before you today as the Chief Justice, Earl Warren Professor, of constitutional law. And what Brown means to me is that none of us is so depraved that they cannot achieve moral transcendence.
Kenji, thank you for that. Andre?
First off, I just want to express my gratitude for the people that had the courage and desire to fight for something like they did, because many of the liberties that I enjoy today wouldn't be here without them. And just from personal experience, I know what it's like to go up against an enemy that seems immovable, seems unbeatable. So for them to feel like they can fight that fight, not only for themselves, but for everybody that came after them, that means the world to me. I cannot express how important it showed legislation to be as an instrument for change, but it showed just how powerful each one of us are. We have the ability to change things. And once we understood that, I think that's what really stood as a catalyst for change for everybody in any minority group.
DeAndre, thank you so much. We do welcome Derrick Johnson. Hello, sir. How are you? President and CEO of the NAACP, who's also joining us right now as well. Mr. Johnson, I don't think you got the chance to hear the question, so I will repeat it for you, sir. The question that we were starting with was, what does Brown v. Board of Education mean to you personally, and how do you think it has affected the trajectory of your life and career?
Brown versus Education represent courage. Individuals who lived in communities under a reign of terror, who by the very nature of them standing up against the status quo could cause them life, economic standing, and for many of them, they were ran out of time. For me personally, Brown represent that time I was growing up in Detroit and on the back end of busing. To realize that one zip code could actually determine the quality of education you can receive as a result of people moving out of the city to the neighboring city for the reasons of not wanting black kids to go to school with white kids, or not wanting their dollars paying for the education of kids who didn't look like them. But also organizationally, Brown means success. That when we stick together and fight together, we win together. And that despite all of the odds that are against us as a community, clear strategy fully implemented based in lived experiences, where people have the courage to stand up, we can and we will win. 70 years later, we're still talking about Brown, even though it's under attack as a result of a few people who had enough courage to stick together and fight together and stay together for all of us to be in this room today.
Derrick, I want to go back to you as we talk about Brown v. Board of Education. I think for some, they sort of simplify it to the case being more so about ensuring that black children could sit next to white children as it relates to their education. Was it about something more, something deeper than that?
Much deeper. When Charles Hubbard in Houston began to envision how to challenge the rule of law separate but equal because he seen it was unconstitutional, that case that he was challenging was about individuals in railroad cars. Had nothing to do with education. It was about separate but equal. And as they began to develop the strategy on how they would attack the Plessy versus Ferguson decision, education became the glaring example that separate could never be equal. Brown goes far beyond just education, but it was never about white kids sitting next to black kids or black kids sitting next to white kids. It was about providing quality education for all children. And we're the only truly developed nation that I'm aware of that we have local education policies to train our future. Japan doesn't do this. There's not a single country in Europe that does this. Australia, Canada, Cuba, which is the most literate population, we allow local industries of a particular region within a state to determine the curriculum of education. In Detroit, you get auto mechanic shop. In another part of the country, you may get something else. Whatever the prevailing industry is based on a 19, 20, or 30 model. We should be thinking broader around education. Is how do we expand the quality of education for all children to develop critical thinkers in a global economy, not a local or state economy, so that we can thrive as a nation holistically, not just a few people.
Janai, this question is for you. Brown was no doubt a seminal case for the Legal Defense Fund. There are so many aspects to the work around school desegregation. Can you tell us in particular about LDF's program for the protection of black teachers during the early days of school desegregation?
Oh, I'm so glad that you asked that question. There's often the critique of Brown that Brown cost our school system black teachers. And I would say it wasn't Brown that cost our school system black teachers. It was the reaction to Brown by people in power who sought to exclude black teaching professionals from the integrated school system. So prior to Brown, there were anywhere between 35% to 50% of the teachers in the 17 segregated school districts, school areas, states. There was a large proportion of black teachers. Fast forward to today, you don't see numbers anywhere close to that in any state. The average number of black teachers is around 7% of the school system. Black principals are a little bit higher, around 11%. Most teachers are white, and when I say most, I'm talking to the tune of about 80%. 79 point something percent of public school teachers are white. And the population of public schools is roughly just a little under, depending on how you count, 44 to 50% students of color. So just look at that. Look at, when you said, when you see it, you can be it. Think about those children in those classrooms. What are they seeing? Who are they looking at as their model of inspiration, as the person who's pouring into them and nurturing them? It doesn't mean that there is no role for white teachers. Of course there is. But shouldn't these students also be exposed to black teachers? Shouldn't they also be exposed to people who, resemble them? And also, studies show that when you are taught by a black educator and you are a black child, your outcomes are better. You're subject to less harsh discipline. You are invested in a very different way. And so just the composition of the faculty and the teachers in our public school system has real serious outcomes. And LDF was always attuned to that. One of the first cases that we brought in 1940 was a case for equal pay between black and white teachers, Alston versus the city of Norfolk. And we continue, because we have a desegregation docket of almost 100 cases, second only to the Department of Justice, we continue to use desegregation cases flowing from the Brown decision to fight for faculty and staff and pay equity and resources, because who teaches you really determines your future in many ways. And I want to give a shout out to our Thurgood Marshall Institute, and we have our director, Carter McCanders, in the back there, because the Thurgood Marshall Institute is the think tank and research arm of the Legal Defense Fund, and we are in the process of issuing a report on black educators and the importance of black educators in our community. So Brown did a lot to create an opening for a more integrated workforce, but we know that there has been a concerted effort to depress the number of black teachers through some of the certification exams. I even know that in the town of Ellery, South Carolina, there were efforts to poll teachers and ask them, this is back right after Brown was decided in the 1950s, they asked teachers about their affiliation with the NAACP to try to ferret out those teachers who might be more radical and who supported integration. And they denied them employment on that basis. So this is not just by happenstance. The lack of black teachers is by design.
This next question is for Kimberlé. How did Brown v. Board of Education help shape our understanding of the Equal Protection Clause of the 14th Amendment of the Constitution, anti-discrimination law right large, and the national conversation regarding equality?
Okay, in a minute, right?
Take all the time you need.
Be done in a minute.
Yes, ma'am.
So I think one of the things that would be helpful is to imagine how equality was thought about before Brown. And you know, it's widely known that Plessy versus Ferguson was the case that constitutionalized segregation, but how it constitutionalized segregation was the issue. So the court did not say that segregation and subordinating black people was okay. They denied that segregation was a subordinating policy against black people. They basically adopted this symmetrical idea. The symmetrical idea is white people couldn't sit in black cars, because the initial case was a transportation case, and black people couldn't sit in white cars. That's symmetrical, right? And if you're treated the same, namely neither one of you can sit in each other's cars, there's no discrimination. At least that's the way they framed it. Now, of course, black people knew better. They knew what the point of segregation was. They knew how they felt about it. They knew what it said about blackness. What the court said about that was, you know what, that's in your own mind. If you want to be free, free your mind, right? Don't think about segregation as subordination of black people. We certainly don't think about it if you all were to segregate us. So the point was to say that they thought about equality in symmetrical terms, in formalistic terms, in ways that you could tell yourself that you weren't being subordinated. Brown changed that, and it changed it by saying, number one, symmetrical treatment is not equality, right? It doesn't matter that white kids can't go to black schools and black kids can't go to white schools. It matters what the message is. It matters what the conditions are. It matters what the experience is. So the court in Brown shifted away from this abstract idea of equality and actually said, we're going to look functionally at how these institutions are actually distorting the futures of black children. That was an important shift, to actually look substantively at what's happening on the ground, not in these abstractions. And here's the last thing that is most important, especially right now. The court said that education was the pathway to democracy. You cannot fully participate in this democracy if you are consigned to institutions that undereducate you and send you the message that you are a second-class citizen. That is a substantive value. It is a substantive injury. The remedy is substantive, not simply procedural. This is important for us to understand, because much of the law that came after that, Griggs versus New Kent County, that basically said, look, it doesn't matter that you're no longer discriminating against kids on the basis of race. You've not dismantled a dual school system. Your responsibility is to turn black schools and white schools into just schools. That is a substantive idea about equality, and that's the one that we're losing now. That's what we have to fight about with this idea that really what Brown was about was colorblindness. Colorblindness didn't appear in Brown at all. And that is a radical reframing of Brown, which we have to fight against.
I want to piggyback off of what you just talked about, and I would ask that you talk to us a little bit about how Brown connected desegregation to democracy and citizenship, and how the contemporary crisis that we're seeing now is a result of a more recent disconnection between the two.
Well, let's start with the idea that I just ended on. So SFFA, which was the case that has widely been cited as destroying not simply affirmative action, which is an overstatement, but also making all diversity, equity, and inclusion suspect. And in case you haven't been reading, everywhere across the country, the idea is, ooh, diversity, equity, and inclusion, that's the new bad word, right? Where does that come from? It comes from a political framework called colorblindness that tries to become the heir apparent to Brown versus Board of Education, when it's its opposite. Colorblindness is about denying the realities of race. It's about returning to Plessy versus Ferguson, and this is not an exaggeration. Colorblindness was first mention in constitutional law by Justice Harlan, who was dissenting in the segregation case. But this is what he said. He said the white race is always going to be supreme in this country, and nothing's going to change that, right? We're colorblind, however. What is that telling us? It's telling us that colorblindness was never meant to be an antidote to racial subordination. Colorblindness was never thought to be that thing that will create racial equity. It was thought to be the thing that doesn't require us to create actual equitable conditions. So now that the court is taking up colorblindness, again, Brown didn't say that, but it's taking up colorblindness as a way to make it impossible for us to talk about the race realities. And that is part of a broader project. We're seeing it in the courts. We're seeing it in our education institutions. We're seeing it in efforts to erase the whole anti-woke war, is the ability to erase the actual conditions that Brown was meant to address. So if we really are thinking about how to lift up the legacy of Brown, what we have to be about is saying, every time they're telling us that we can't tell the truth about what race does, every time they're saying we can't tell the truth about what desegregation was all about, every time they try to erase the story of Ruby Bridges because it hurts the feelings of white kids, every time they're doing that, they are distorting the legacy of Brown. It was the Supreme Court that said it matters what happens to Linda Brown. It was the Supreme Court that said if we cannot support integration, if we cannot understand the connection between segregation and democracy, we're failing at what our promises really are. So at this point, in this moment, we've got to connect the attack on democracy to the attack on racial justice. They are one and the same. We can't have a democracy by leaving racial justice on the side of the road, and we can't have racial justice with not supporting our democracy.
No doubt those themes are all connected, and we can't extrapolate one and believe that we can be impactful in the other spaces. I want to turn to Mr. Castro right now. Given your background as a former city council member and former U.S. Secretary of Housing and Urban Development, can you tell us how education equity fits into the broader fight to lift communities of color out of poverty and boost economic mobility and quality of life for all?
Yeah, it's foundational. I mean, I think so many of us here who feel like we've been able to live out our dreams know that the underpinning of that was getting a good education. And we've also seen the opposite, right? I grew up with a grandmother who had come from Mexico when she was 6 or 7 years old and only completed 3rd grade. And because of that, she worked as a maid, a cook, and a babysitter. And that's honorable work. Mm-hmm. But it also means that, you know, financially she was never stable. It meant that she was never really able to achieve her dreams. And then I saw my mom become the first in her family that graduated from high school and was actually able to go to college and actually eventually able to get her master's degree. And then my brother Joaquin and I graduated from high school, graduated from college, went to law school, graduated from law school, the first to become professionals in our family. And so I think at a personal level, at a family level, it underpins so much of the success. And then also, and this is true of, in my old neck of the woods of housing, it connects to everything else. If you have a decent education, because of the pathway that Brown created and everything else that continues, the advocacy and, you know, the policy and the resource investment, because we can't forget, even though we had legally Brown and, you know, we had the all deliberate speed, and they deliberated as long as they could. Some of them are still deliberating in different places, including in my home state of Texas. You know, I grew up, I mentioned, in the SAISD and Edgewood districts. And those of y'all may remember constitutional law. Those were the 2 districts that were part of the SAISD versus Rodriguez 1973 case, where in a 5-4 decision, the Supreme Court said that education was not a fundamental right and struck down the challenge to Texas's school financing system that never, you know, that basically didn't get really addressed until 1989 in a state case. But the resources were not there, right? It's taken forever in Texas and New Jersey and so many states across the country to address that issue. So Educational equity is an underpinning of the ability to succeed, and it's connected to housing, it's connected to job opportunities, connected to every other indicator of quality of life and of economic advancement. And yeah, you know, I saw that on the city council in San Antonio and as mayor and at HUD in visiting 100 different communities, large and small.
So I want to piggyback off of that, your work as an elected official. How have electoral coalitions advanced equal educational opportunities in the United States, and how do multiracial coalitions remain important in the overall fight for equality?
Oh, they're fundamental. I mean, this assault that we see, I mean, we're right, as you said, we're right in the middle of the raw backlash to the very little and sometimes just in name only progress that we made in that year and a half or 2 years after the murder of George Floyd, where every corporation was saying, yes, 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 we'll do something. And then 2 years later, they're the ones backing off of any kind of equity investment, you know, DEI, all of that. They never, so many of them, and this is one of my biggest frustrations today, never really believed in it in the first place, mouthed it when they had to, and now they're the first ones to back off of it when they feel a little bit of pressure, right? And the only antidote to that is, as voters, as consumers, as people in power on boards of directors, as policymakers here at the Capitol and state legislators and in city halls, to form coalitions, you know, black, brown, Asian American, Native American, everybody, to push back on that. To you know, it's the old idea that power, nobody's going to give up power. You have to go and you have to, through our democratic means, take it, right? Through lawful through lawful means, peaceful means, which is what distinguishes, I think, the folks here from what we saw on January 6th. But, you know, and I saw, last thing I'll say on this is I was really inspired. You know, I ran for mayor, became mayor of my hometown in San Antonio when I was 34. And I had seen Henry Cisneros become the first Mexican-American mayor of a major city. I saw with Henry and then in my own election, I couldn't have won without the black community in that city. Like, it was fundamental, the coalitions that were formed. You think about groundbreakers like Harold Washington or Tom Bradley, and it was the opposite. It was the Latino community in Los Angeles also, and people coming together at the city level, the state level. Barack Obama, and remember the images, and some folks may have been there in Grant Park that night in '08, of how diverse that crowd was and that coalition that he put together. We've made progress really faster when we build these coalitions and hold them, especially in the middle of the pushback.
Thank you. Kenji, Julián just spoke about his experience as an elected representative, but also we know that in this current day and age, policy change can also come from corporations as well. As the director of the Metzler Center for Diversity, Inclusion, and Belonging at NYU School of Law, can you tell us about the 2023 decision and Students for Fair Admissions v. Harvard, UNC SFFA, and how that diverged from the Brown 1 and 2 decisions, and how the change in DEIA in schooling impacts DEI in corporate America as well?
Kimberlé has already set me up beautifully for this, so thank you for that. The SFFA decision was decided on June 29th of 2023, and this was a case that abolished racially conscious admissions in public and private universities. And the good news about it is that even that kind of decision needs to pay homage to Brown. So this is, if you believe that Brown versus Board of Education was wrongly decided, then you yourself are wrong, right? And so everybody's trying to plug themselves into the energy of Brown. But as you saw people trying to justify SFFA, they did exactly what Kimberlé was just describing, which is to say, oh, Brown stood for this principle of colorblindness, the so-called anti-classification principle. As Kimberlé also said, there's nothing in Brown that talks about colorblindness, and there's a lot in Brown that talks about the opposite of that, which is the anti-subordination principle. So in constitutional law, we often talk about the anti-classification principle and the anti-subordination principle. Very briefly, the anti-classification principle says it's racial classifications in and of themselves that are wrong because they teach us to look at each other only as members of particular racial groups. And so the remedy to that is colorblindness. and therefore that is what the right wing of the court is embracing now and also in the SFFA decision. The antidote to that, the other view, is the anti-subordination principle, which is to say classification in and of itself is not problematic. It is the end to which that classification is put that is problematic. So if you are actually using classification in order to subordinate people on the basis of race, that is a problem. But if you're using a classification in order to lift up a historically subordinated group, that's a different thing entirely. It doesn't seem like this is rocket science or should be we shouldn't need to explain this to people, but somehow we do, right? And the best way I know to explain it is through the words of the late great Justice John Paul Stevens, who says, to say that there's a moral and legal equivalence, right, between Jim Crow, right, and SFFA or affirmative action, is to confuse a no trespassing sign with a welcome mat, right? And so it's just really important for us to understand that what happened in SFFA was a travesty and a betrayal of the promise of Brown, even as people are trying to put forward the idea that it stands in the shadow or in the path of Brown. So that's sort of thought number one. Thought number two is that in corporate America and in universities and in law firms and contexts around the country and nonprofits and workplaces of all kinds, DEI is under attack in the wake of SFFA. So again, I loved what Kimberlé was saying about how the meme that's out there is SFFA means that diversity, equity, inclusion is dead. And I want to say that that's a gross exaggeration. It is true that this kind of YOLO court is going to keep going, right, and keep embracing the anti-classification principle, I believe, probably in the Title VII context in Section 1981, in contexts that will affect private employment. So that's not what, where I think the hope is. Where I think the hope is in what Justice Sonia Sotomayor said in her dissent, which is to say diversity is now a fundamental American value. It is immovable. So what she's saying there, she's not talking to her colleagues anymore. She's talking to us as the American people. So as often she's doing these days, she's not talking to our colleagues on the court to try to persuade them. She's talking to the American public to say if we remain true to our ideals, we are actually going to be the immovable object. So what happens when the irresistible force meets the immovable object? Because when the Supreme Court interprets the Constitution, that is an irresistible force. My answer to that is that the object changes. Because the force is then not resisted, it's absorbed, and the object is not moved, it is transformed. So what I think is going to happen to DEI is that it is going to morph in various ways to avoid certain kinds of things. So instead of saying, we're going to protect these particular cohorts, it's going to move to content. So instead of saying this fellowship is available only to Black individuals or Asian individuals, it's going to say this fellowship is for people of any race who are pursuing Black equity or the advancement of Asian equity. And there are going to be various kind of moves in that vein that are going to keep diversity, equity, inclusion alive, so long as we remain true to our own ideals. The last thing that I will say is that when we talk about colorblindness, I just want to note with Neil Gotanda that colorblindness is a metaphor, right? So what they are trying to say to us is that legal colorblindness and medical colorblindness are the same thing, but they are not. Medical colorblindness is an actual phenomenon. If I'm red-green colorblind, I literally will not be able to tell the difference between red and green. So I will not be able to tell the difference between what Kimberly's wearing and what Janai is wearing today, right? But if I'm legally colorblind, that doesn't mean that I can't tell the difference between a Black person, a white person, and an Asian person. That just means that I pretend to do that I think it is problematic, and so I'm going to say, I can tell the difference, but I'm going to pretend that I can't tell the difference. And so I believe in medical colorblindness. I do not believe in legal colorblindness, because legal colorblindness is a fiction and a metaphor. And Janai, the final thing that I'll say is, the last thing I want us to note is that when people talk about this backlash to DEI, which we're reading about in the paper every day, there is a concerted effort to shut down DEI, but it's not a backlash, right? So now I'm going to borrow from the words of Mary Bonato, because remember what Janai said earlier when she said, don't blame Brown for making Black teachers lose their jobs. You're putting the blame in the wrong place. Don't blame DEI for the backlash. People are saying like, oh, George Floyd got murdered, then you had this big effort in DEI, and now you've overplayed your hand and you're experiencing the backlash. And I would say that is not backlash. That opposition has always been there. So let's not call it backlash. This is just lash, right? And so if we think about it as lash, this is always going to be there. This is going to be there for the rest of my life, for the rest of your lives. So we just have to understand that we can't get cowed, we can't back down, we can't apologize because somebody is telling us we overplayed our hand and this is a consequence. Rather, we have to say, this is always going to be there. This is already there, it will always be there, and there's nothing to do but to fight it.
Make it plain, Kenji, make it plain. DeAndre, speaking of DEI in higher education and the student plaintiffs in SFFA, I understand that you are currently an undergraduate student and an LDF client who began as a student plaintiff back in 2020. Your case concerned discriminatory dress and grooming codes. What inspired you to step up and be a plaintiff as a high school student, and how do you see your discrimination, your hair discrimination fitting into the larger picture of racial justice?
So for me, starting off, it started at my house. It started at home. I was always told that I was good enough. I was always told that my image was good enough. I was perfect the way I was. I knew that going into it. So whenever they tried to disguise discrimination as simply a dressing and grooming policy, I knew what was going on. So I knew what I had to fight for. There's too many people out there that don't have a voice or don't feel like they have a voice. So I knew I could be that person for her. I knew, even personally, my cousin was coming right after me. They were going to do the same thing to him. So I'm going to fight for him. I care about my people. I love my people in every shade that they come in. And I will always fight for them. And I've always felt like people of color's appearance has been under scrutiny in the workplace and in society for so long. They've always told us, you don't look professional. You don't look like you could be a doctor. You can't be a lawyer. You can't hold any type of high-ranking position in life because of what you look like. And I knew from what my parents told me, from what my family told me, I could be anything that I wanted to be. And that's what I'm fighting for, because I believe any of us can be whoever we want to be. And beyond that, I'm going to be a veterinarian right now. Nobody expected that out of me. They look at me and there's a lot of things they think I might be, and it's not a veterinarian. So I'm here to prove it to them. I can do it, and you can do it. And the way I feel like this plays into the bigger picture is we have to show in every aspect of our life we're willing to fight for everything. You will not be able to oppress us in any way and think you can steamroll us. We're gonna fight, just like the people that came before us.
DeAndre beautifully said, thank you so much. Derrick, DeAndre just spoke about his experience as a student plaintiff. The NAACP chapters have also been plaintiffs in many desegregation cases. What is the importance of institutional organizational plaintiffs in the fight for education equity?
You think about the NAACP, we have close to 2,600 chapters in 47 states. And everywhere we have standing. What has happened over time is if you have local people who are having probably lived experience, they have to lead the fight. What we have learned, what I have experienced, if you have lawyers who parachute in and parachute out, that's not the community's fight. And over time, what happens, everybody has energy. You file a lawsuit, takes a long time to go through the court. 5 years later, the lawyers come back to town and say, hey, we won. But people have moved on because they're living the everyday experience. Having institutional plaintiffs with people who are making up those institutions, who are part of the everyday struggle, is really important. Secondly, an expert is someone who knows a little bit more than everybody else in the room. There are no better experts than people who live the experiences that they're fighting against, because they are living it, they're there, they know the nuances of it. I remember when I first finished law school and I was doing some community organizing. We went to this one particular place and we was trying to figure out an equal protection claim. And we're sitting there and it was about 12 local community people in a city, true name, called Duck Hill, Mississippi. And in Duck Hill, Mississippi, the folks in there, you had 2 retired principals, and everybody else was lunchroom attendants and probably had not finished school, more or less been to college. The expert in that room was Miss Mary. Miss Mary had not finished high school. And as the lawyers who was in the room sitting there, she said, I don't think it's right that them folks up there in Winona get to vote for our superintendent and we can't vote for their superintendent as 2 separate school districts. That was the claim we was looking for, but none of us had any clue that that was taking place. Ms. Mary was also the branch treasurer for the NAACP. She's a part of that community. She lived the experience. And so when the lawsuit was ultimately filed and won, it was because she could see what no one else could see because she lived that reality. Having people organized on the ground is the most essential part to any movement. Kwame Ture, Stokely Carmichael used to say, organize, 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 whether it's your Sunday school class, your church, or whatever organization it is, because we have to have a presence, and no matter what your vehicle for voice is, be it NAACP or you name the organization, we must be organized on the ground and prepared for the fight, because in numbers come courage, and with courage come victory.
Janai, can you tell us how LDF is working to advance the goals of Brown v. Board of Education and defend and advance the proper interpretation of the Equal Protection Clause and anti-discrimination law today?
Yes, so I already mentioned that we have a very robust desegregation docket that allows us to go into school districts through our consent decrees and other mechanisms to advance education equity. But we also have been involved in every single Supreme Court case challenging affirmative action, including this last one, and this was the first one that actually reduced affirmative action to almost nothing. But one thing that I think we've realized over time, and we've always known, is you can't play this only as a defensive game. You just can't. And I think that over time, the effort of civil rights communities to be very careful about preserving what we have has perhaps led us not to be as imaginative as some of the plaintiffs in Brown. And in this moment when there's almost nothing left to lose, this is the moment for really grand and radical imagination. And so we have launched something called the Equal Protection Initiative, because we want to reclaim the Equal Protection Clause. We want to reset the interpretation of Brown in the same way that you heard today on this stage, people saying what Brown actually is and not recasting this as some racial harmony decision, and recognizing that Brown was actually extraordinarily race conscious. Brown required busing of students based on their race from one school district to another in order to effectuate integration, in order to reallocate resources. It was very specific about race, very clear in looking at race and using it as a mechanism to remedy past discrimination. For those of you who follow affirmative action, you know that over time, the idea of remedying past discrimination was what became taboo. And instead it was replaced by the idea of diversity. Now, I think that we have all come to understand diversity is a very valid principle and value, that diverse teams produce better results, that diversity actually, really sharpens us in so many ways. But that doesn't mean that we can't do both and. It doesn't mean that we can't embrace diversity and not say, and yet there's still remediation that needs to happen. And so we need to bring that back to the table. We need to bring that back into the discussion. And we need to be thinking about what new legal doctrines are required to support this multiracial democracy. So our Equal Protection Initiative draws upon some of the coalitional work that you talked about, Julián. We have something called the Advancing Racial Equity Alliance. So we're working with Latino Justice, Asian Americans Advancing Justice, the National Women's Law Center, the National Center for Lesbian Rights, all of the groups that are directly implicated and impacted by this assault on DEI and this misconstruing of Brown. And so we are in various jurisdictions trying to advance new ideas about equal protection. And Kim, you know this very well. This also dovetails directly with the assault on truth. So we also are trying to push back on those very pieces of legislation that you talked about that cause people to feel anguish and guilt and, all of those feelings. And we're saying, yeah, you need to feel that. You actually need to feel that, because when you feel that, that actually propels you to action. It actually makes you realize there is something fundamentally unfair and you need to change it, right? We all need to be a little uncomfortable with this status quo. We all should feel a bit guilty about the inequity that still exists 70 years after Brown. I want us to feel that anguish. There's nothing wrong with that. And so we are pushing back. We are in a number of states, including your state of Texas, South Carolina, Florida, pushing back against legislation that would suggest that certain concepts like critical race theory, which Kim Crenshaw was one of the foundational people to advance, right? I wish they were teaching critical race theory in K through 12. I think we'd all be better off if they were, right? But the reality is there are many different ways, and one thing I want to leave you all with is that we need to get involved in our public school system. Derrick talked about the fact that every state and locale gets to determine its own rules and curriculum. We have people like Moms for Liberty showing up at school board hearings and talking about the anguish that little Jimmy and Jane feel. We need to go tell our stories about what it feels like to be excluded from curriculum, about not having our stories told and our children taught about their greatness and their history and their triumph. Why don't we talk about the anguish that that produces for Black children and other children of color and other marginalized groups? So I encourage everyone to find a way to get involved in their local school system, because that is a fundamental battleground and it is a direct link to democracy. Brown said that education is all about citizenship and it's all about participation, and that is about power. And that is why Brown is such a contested decision, because it ultimately leads to the empowerment of these communities that have been marginalized, and especially Black communities.
Janai, thank you so much. Speaking of closing, that brings us to our last question for the night, and we will start with Derrick with this one. If you were to give advice to young people who are taking up the baton of fighting for educational equity, what would it be?
Understanding all the squares of power. That litigation is an avenue, but not the only avenue. Electoral power is an avenue, but not the only avenue. Narrative control is an avenue, but not the only avenue. Addressing corporate behavior is an avenue, but not the only avenue. Legislation is an avenue, but not the only avenue. But protest and demonstration is a tool to get to power. And if you understand the squares of power and the tools to get to it, then you can be more effective. Emotionalism without strategy is a shout. A strategic shout can have change, make change. And none of our movement was based on a us versus us paradigm, men versus women, young versus old. It has always been most successful when it's intergenerational. We understand all the squares of power, and we had complete control of the tools that we use, because demonstrating for no reason is a waste of energy. How many of y'all seen Malcolm X movie and the people coming out of the church and he said, oh, you seen Jesus now, you're coming back to the same hell before you went into church. We have to be much more strategic in how we approach it and embrace our young people's energy, encourage it, and layer it with real wisdom. As those of us who are neither young or old and in the middle, be the connective tissue. We have the ability to make the change, but we must do it together and not separate from each other.
Derrick, thank you so much. DeAndre?
I would say, first off, you have to prepare for hardships. It's going to be hard. Typically, the good thing is never the easy thing to do. But knowing us, young people, we hold the keys to change. We've had some wonderful people come before us and fight for us. We have some wonderful people standing here that have fought for us. We have next. We can do it. All we have to do is stand together. We can change this society into our utopia as long as we desire that.
DeAndre, thank you. Kenji?
I would love it if folks engaged at every level, from the very grand kind of utopian, let's reimagine society level that Janai is talking about, to the mid-level institutional level that Derrick is talking about, but even to the micro level, right? If someone says to you, diversity, equity, and inclusion stands for didn't earn it, right? So bridge falls down, people says DEI stands for didn't earn it, blames it on D&I. I want you to clap back immediately and say, no, DEI stands for doubly earned it, right? So I want us to have those snappy, fighting responses, right, at the retail level, as well as thinking about these grand issues of strategy on the more holistic level. And then we're going to get tired, inevitably, right, when we do all of that work. And when you get tired or sad or depressed or exhausted, I just want you to think about this. Why is it that this is such a pitched battle? Right? And I want to argue that this is such a pitched battle that we feel like we are fighting so hard right now and oftentimes losing a battle here, a battle there, precisely because we have succeeded, not because we have failed. It's precisely because Brown has succeeded in transforming society that this is a fight. Right? So people know that demographics are behind us and that by 2042, we will be a majority-minority nation on the basis of race. That is already the case for people under 18 today. We are majority-minority. Whites are a minority of the population. Women are more than 50% of college-educated workers since 2019. The LGBTQ plus population is at 20% in Gen Z. 20% of Gen Z identifies as something other than cishet, right? So with those demographics, these broad, irreversible trends, we know who's going to win in the end. So I always think about that labor organizing quote that says, first they ignore you, then they laugh at you, then they fight you, and then we win. Because when I was thinking about DEI 15 years ago, when I just started out, people didn't even know what it was. And then people laughed at me. They said, you're in the most prestigious field in law. You're in constitutional law. Why would you go over and do this fringe thing over here? And I was like, they're the same project, people, right? Now nobody is laughing. Everyone understands the fight over diversity, equity, and inclusion is a fight for the identity and even the soul of this nation, right? And given everything that I've said before, given that we have the legacy of Brown, there's no doubt in my mind about who is going to win that fight.
Thank you so much, Kenji. Kimberlé?
I think we have to first acknowledge that the fight for our future involves a fight for our history. We all know that adage that those who don't know their history are bound to repeat it. I think the faction of this country who believes that the most is the faction that's trying to take our history away from us. They understand that if we understand that the whole adage, the whole frame that your civil rights violate my civil rights is an old page out of a very old book. It's the whole way that Reconstruction was deconstructed. It's the way that massive resistance resisted Brown, right? The idea that integration was actually a denial of white children's right to segregation. That was a legitimate argument that people were trying to make. It's an argument we thought was put to rest. And now we see it come back in the very terms of this anti-woke education stuff. To tell your history is to violate the rights of certain children. To actually have a full, comprehensive understanding of how we've gotten to this point is un-American. This is all stuff from a playbook that we've seen again and again and again. So when people are trying to take something away from us, whether it's our vote, whether it's our history, whether it's our words, our concepts, it's telling us that that stuff is valuable. It's telling us that we have to put all of our resources together to fight it. So what are the implications for what we say to each other and what we say to our children? One is pivoting did not work and it will not work. So the idea of saying, oh, we're not teaching critical race theory, how'd that work out for us, right? exactly what we could have predicted happened. They moved from the attack on critical race theory to the attack on Black studies to the attack on GPQTIA studies and queer studies to now the attack on diversity. It's an appetite that cannot be satisfied by throwing a few of us under the bus. We have learned this over and over again. If there's one thing that we should always remember, is that if they take away your ability to learn and understand your history and your current reality, you can't transform it. So that's why the fight for our right to vote has to also be a fight for our right to learn. It's why 2 weeks ago today, a lot of our organizations were right here in the Capitol fighting for the right to learn. It's why we launched this summer. This is the 60th anniversary of Freedom Summer. Yes, we should celebrate, but we need to actually elevate what Freedom Summer was all about. It was understanding that it's not just the right to get the vote, but the right to be educated and literate about what you're voting for. And that means untelling some of the lies about what this country has been and how we have been situated in it. So of the many things that I'm hoping that our students and our young people, and I know they have because they were there last week. I see one of them right here. NAACP brought their youth out in full force. Other organizations did too. So I'm about passing on this baton, but with this recognition, it may be true that the arc of the moral universe bends to justice, but somebody's got to be doing that bending. And that is what our young people are doing, and I can't tell you how proud I am of all of you. I feel like, you know what, we might be ready to retire pretty soon, so y'all take it.
Mic drop on that one, Kimberlé. Thank you so much. Julián?
My advice, my perspective to young people would be to love yourself. We still have in our communities a lot of internalized oppression. A lot of internalized oppression. I see that in our community in kids who are ashamed to speak Spanish or of the food their parents eat or seeming too brown, too cultural in a certain way, right? And that's all of the stuff that's been piped in over the generations. And so love yourself for who you are. The color of your skin, your culture, your history is worth loving, just like anybody else's. And then also I would say that you hear a lot, because it's true, that you're the future, but you're also the present. You already have a tremendous power to you, a tremendous wisdom and energy and idealism that can move mountains when it's channeled. And so go out and do it. Keep doing it.
Julián, thank you. Last but certainly not least, Janai.
Well, there's been so much wisdom shared on this stage already. I will say that however you want to call it, we call it an inflection point, we're at a crossroads, all of those things. The reality is this is a very critical moment for our democracy. And I've often talked about this trifecta of assaults that we are experiencing. And to me, they are all coordinated because there is an effort to erase the power of young people, this generation who will be more demographically diverse than any other this country has ever known. And people are very cognizant of that. And so there is a direct attack on the freedom to learn. There's an assault on truth and history, because that knowledge is power. I don't need to even explain that any more clearly. There's also an attack on the right to vote. And we see that in the proliferation of voter suppression laws across the country. And there is an attack on the right to protest. We see how protesters of every sort, from the Black Lives Matter protesters to the protesters on campuses now, are being treated in a way that is directly violative of the First Amendment. When you combine those three, you will eventually not need to harm people who are protesting or voting if you take away the truth. there's nothing to protest about because they don't even know. They won't even know. You won't need to take away the right to vote because they don't know what to vote for if you've taken away their truth and their context and their history. So this is a really diabolical trifecta of assaults that is being visited upon our young people. And we must push back. And what gives me hope are people like DeAndre, who, when I heard about his case, a few of us lawyers, and I see one of his lawyers in the back of the room now, went to Texas to visit with him. And the moment that I sat down with DeAndre and his family, it was clear to me, not only did we need to represent him and eventually his cousin, but that it is young people like him who will deliver us from this with our help, right? Because we are not absolved from this as folks of a certain generation, right? I'm not gonna say it's to the young people only to do it. We have got to do this together in partnership. We've got to learn from one another and be inspired by one another. And I often talk about this generation's entitlement. And so you talked about internalized oppression, and we see that too. I also just see a little bit of entitlement, which, you know, as a parent can be a little frustrating. But as a civil rights lawyer, when I hear young people say, you must call me by my pronoun, even if you get it wrong sometimes, but you must call me that because that's who I am and that's how I want to be identified. And you owe that to me because I'm a human and you must respect me and my dignity. I love that. I love that. Those are things that we were afraid to say, that we were afraid to be insistent upon. When young people come and say, I don't have to be so perfectly respectable to be respected. I love that, right? There's a liberation in that. That is true freedom. When we can be who we are, all of who we are, when we can buck the assumptions and the stereotypes. So there's something very, very inspiring to me about this generation of young people who are struggling with real issues, but who also bring a sense of entitlement to the conversation. And we've got to be open to listening to that and respecting that. And I am just very honored to be able to represent young people like DeAndre as part of our work, because investing in young people is truly the investment in our future and our democracy.
I think that's a great place to leave it. Let's give it up for our panel. A lot of important lessons have been shared here with us today. I think we all understand what the objective is moving forward, and I hope we all get to work. There's a lot to do. We have great organizations that are committed to that. We thank them for what they are doing and will continue to do, and let's continue to join the fight and aid them in these efforts as well. So thank you.